जिंदाबाद साथ जिंदाबाद साथियों। आज के इस वेबिनार में आप सबका स्वागत है। वी आर ऑल वेरी हैप्पी टू सी यू हियर। आई एम कात्यायनी, ह्यूमन राइट्स लॉयर वर्किंग ऑन लेबर लॉज इन बिजनेस एंड ह्यूमन राइट्स। जैसा कि आप लोग जानते ही हैं, आज का वेबिनार इनफॉर्मल वर्कर्स बिल पे फोकस्ड है। The Informal Workers Bill is a model law that has been drafted collaboratively by trade unions across India and the Center for Labor Studies as an alternative legislation securing rights of informal sector workers. Today, we have Professor Babu Mathew as our chief speaker and Senior Advocate Gayatri Singh as the moderator for the discussion. Not that either of them need an introduction, but हमारे युवा साथियों के लिए मैं एक छोटा सा इंट्रोडक्शन जरूर देना चाहूंगी। प्रोफेसर मैथ्यू इज अ प्रोफेसर ऑफ लॉ एंड आप को डायरेक्टर हैं सेंटर फॉर लेबर स्टडीज एट NLSIU Bangalore. He is closely associated with trade union movements and is a leading authority on child labor, bonded labor, and destruction of livelihood of the marginalized communities. Senior Advocate Gayatri Singh is an eminent human and labor rights lawyer, appearing before the Bombay High Court and various labor tribunals and courts across India, with almost 4 decades of practice behind her. She is also a co-founder of the Human Rights Law Network. Thank you, both of you, for taking out the time to share your approach and experiences on the Informal Workers Bill with us. Before we move on to the discussion, I would also like to quickly introduce NAJAR. The National Alliance for Justice, Accountability and Rights, yani NAJAR, is an all-India democratic forum of independent legal professionals. ये forum जो है NAPM के अंडर आता है, National Alliance for Progressive Movements. Among our members are practicing advocates, legal faculty, activists, students, and researchers. अगर आप में से किसी को interest हो join करने में, तो please do get in touch. Thank you very much. Over to you, Gayatri ji.
Just a minute once. Yeah, so good evening, everyone. And we will have a sort of a lengthy talk by Babu Mathew to explain to us the contours of this new legislation and why it is important. I was just looking at all the people who have joined. Most of them are activists in their different areas, as well as lawyers and law students. We also have the International Law Forum, which has joined us. That's an South Asian group of lawyers. So basically, I really don't want to take too much of time, but I just want to place it in a context, which is to say that, as everyone knows, informal workers are unprotected. There is no labor law which is applicable to them. And it is not just informal sector workers who are being deprived of protection, but it is also within the formal sector, the workers are on a large scale are being casualized or being taken into as contract workers or under fixed term contracts. So basically the rights that even formal workers had with regard to permanency and security of tenure, that also is being slowly taken away. So the question that is before us, and I think that it's not just the lawyers who have been fighting, but it's the activists and trade unions who have taken on struggles in different sectors. And I think that success of those struggles also we should note, which is basically boards which have been set up, whether it's the domestic workers boards or whether it's a construction workers board. And in Maharashtra, we have the Mathadi Workers Board, the Dock Labor Board, as well as the security guards boards. And in the South, we have several boards for different sectors. So in their own way, workers have been fighting at a sectorial level, but there are a large number of workers who are left out. And the question is, what is it that how do we define a worker? That's one. And who do we consider is an employer? And basically, it is this definition of worker and an employer which is disguised. And the fact that it is hidden is one of the reasons why workers are being deprived of their rights under the various laws. So I think this bill that has been drafted by Babu Mathew and various other activists from different areas is a good way in which we can start a discussion on how we see informal sector workers being taken into consideration and how they can be protected under the law. And I think this discussion would be helpful. And that is why we would like to give a substantial amount of time for discussion. And people can put in their questions in the chat box because we might not be able to have everyone speaking because of the shortage of time. So I would just open the discussion with Babu Mathew, and then we can take it there in terms of the question and answers. Thanks.
Thank you very much, Katyani and Gayatri, for the preliminary remarks and for introducing me and initiating this discussion this evening. I think it is a very important opportunity for all of us to work with the trade unions, both of the organized sector and of the informal sector. And I think if we look at everything that has happened and is happening, the amount of experience in India is so tremendous that, if we all work together, or even a substantial number of us work together, then the output is bound to be phenomenally impressive. We have the potential for creating new labor jurisprudence, which is especially meant for the informal workers. And indeed, that is the crying need of the hour. In our case, we started at the Center for Labor Studies, and without waiting for even a day, we contacted the trade unions that work with the informal workers. I must mention it is, Nalini Nayak and Sonia from Trivandrum, and Geeta Ramakrishna from Chennai, and Chennai from the agricultural workers movement, and of course, a friend from Delhi in the construction workers movement. And in Bangalore, we had many friends, and those of us who work at the Center for Labor Studies. So this, whatever has been created, the drafting, etc., does not belong to one person. The chief draft person is a PhD scholar of the National Law School, and her name is Jasoon. And so all of us work together to produce this document. And I'm happy to mention that it has been discussed with trade unions of the informal sector in Bangalore, in Delhi, and in Mumbai. I think the meeting that was attempted in West Bengal did not fully produce results. And so that's a gap which exists. But otherwise, we got tremendous feedback. And I am a bit apologetic that we have not been able to take on board all the feedback received. But that's no reason why feedback should not continue. We feel that quickly there must be one more collective effort in order to take note of all the feedback and keep on improvising this draft. And so in that sense, it's really work which is in the pipeline, it's ongoing work. And so I invite all listeners to kindly take the draft in that spirit and make your critical comments, etc., in order to improve upon what we have so far done. I must say that the 4 labor codes certainly triggered off this initiative. We have been watching the 4 labor codes from the stage at which they were bills. And so I think by now 3 to 4 years of reflection on the labor codes and related matters has taken place. And there are so many things about the labor codes which I'm not going to get into just now. But I must say that one leading conclusion that we came to was that the labor codes are primarily meant for the organized workers. The informal workers have been neglected in these codes. Though, if we must get into a very thorough discussion about that matter, there may be need to enter a caveat or two in order to pull out a few elements from the rather discredited codes to see how they can be twisted and turned around in order to help informal workers. So that is certainly part of the reality. As Gayatri was mentioning, we lawyers, or at least the legal fraternity, especially of the Anglo-Saxon variety, has specialized with a form of statutory drafting, which creates so many obstacles for achieving even the purpose for which the legislation is said to be enacted. And I think the leading one there is what we might also call as jurisdictional definitions. All of us who are familiar with labor law, we have seen how much of struggle there has been in respect of such definition clauses in the Industrial Disputes Act. It is said by scholars that if you were to plot the definition of industry on a graph, then you will get a zigzag curve. And that zigzag curve was brought to an end only by Justice Krishnaiah in the famous Bangalore Water Supply and Sewerage Board in 1978. Since then, the law on this regard has remained stable, but we are all aware that the Supreme Court is planning to revisit it, even after the Industrial Relations Code has accepted the ingredients of Krishnaiah's judgment. Not fully, but quite substantially. So I mentioned this in order to say that those who drafted the four codes keep saying that the attempt was to simplify the codes. If we look at the Social Security Code, it starts with 91 definition clauses. How can anybody call such a statute as an attempt at simplification? So I don't think these alibis given in order to draft the four codes holds any water. And that's the reason why we have strongly felt, as Gayatri has already hinted, that this definitional trap we want to avoid. I think that definitional trap is best captured when you look at the definition of gig workers and platform workers, where they go out of their way to say that, the gig and platform workers are outside traditional employer-employee relationships. So a question of jurisdictional fact is converted into a dogmatic legal statement. And that is the direction in which labor law would like to proceed. And so we begin by using a definition in this statute, which permits everybody, all those who are part of the workforce, to be covered by this legislation. And when we say that we want all to be covered by this legislation, we did a preliminary classification of the workforce. We all know that more than 90% of the workforce is in the informal workers group. But in addition to that, we took note of the classification into wage workers, into self-employed people, into gig and platform-based workers, and into those whose livelihood is earned in relation to natural resources, in relation to the commons. So that's the whole gamut. And it is that segment that we propose to cover. We've also, indicated that there can be exhaustive schedules to this law in order to indicate who's covered at a point of time, and that can be expanded in order to make it even bigger. So definitional trap we want to overcome by opening it up to make it universally inclusive and not follow the pattern of excluding XYZ category of people. That's the first point that I want to convey. The next thing is, where do we draw the values in relation to the effort that we are making? Very clearly, we draw values from two sources. One, of course, is the Constitution of India, and the other is the ILO standards. So far as the Constitution is concerned, the fundamental rights itself gives us so many valuable labor rights. And in addition, if you read it along with the directive principles of state policy, in fact, we did an interesting exercise to contrast what is it that core labor standard gives, what is it that decent conditions of work from the ILO give. If you compare these two sources, they almost converge 100%. So that's the extent of standards laid down by our own constitution and by the ILO. It's another matter, and I think I must not fail to mention this. Increasingly, we find less and less adherence to the ILO standards within the ILO itself. I suppose that is what we are witnessing even vis-a-vis the Constitution. So this, disruption played by neoliberalism is certainly an obstacle. I would pose the question, is it not time for us to call out the ILO? What faith do they have in the core labor standards or in decent conditions at work? I think that is also requires to be taken a note of. Coming to the legislative process that we have adopted, we have learned hugely from the experience of the trade union. And I must say, as I said earlier, both informal workers and formal workers. And so far as informal workers are concerned, I must say that a major lesson that we have learned from Subhash Bhatnagar from the Construction Workers Union in Delhi is his continuous pointing out what has been happening to the so-called registration of members into the welfare board. And sorry to use an expression which is not very pleasant, that is the existence of bogus membership. And bogus membership is promoted by bogus trade unions. So that is a leading issue which we must reckon with. And for that reason, we give a lot of importance to the registration process. When we say registration process, we mean universal registration of all informal workers, going far beyond the present definitional traps. So we must get all of them on board. And for this, there must be a district level registry. We have seen that national level registries are not enough for this purpose. They are subject to excessive centralized control. And therefore, we must ask for it at the district level. But that does not mean it must stop at the district. It must go to the Gram Sabha and the ward committees, and a process must be set up in order to build the registration from bottom-up methods. And this district level registry should be comprehensively created, made available to the public. In order to facilitate that, some steps that we have thought of. One is that every employer must maintain a muster roll. And in that muster roll, there should be the name of everybody, irrespective of whatever designations they may use. It may be casual, it may be permanent, maybe temporary, it may be badli, it may be contract workers. All varieties of workers, irrespective of their designation, will have to be entered into the muster roll. And that muster roll will have to be shared with the district registry. There must be a senior officer whose job is to maintain such a registry. Of course, the more difficult part of it is when it comes to self-employment. And there, I think we need more innovative ideas. We have been mentioning that self-registration is necessary when it comes to self-employment. But how to make sure that evils of loose membership does not creep in through there. So that is again something Of course, there is always the rule-making route, but the statutory provisions must also add clarity to this. I would flag this as an issue which requires more attention. Similarly, we need a list of contractors and a list of employers, and all that must become available and in the district registry. This is not just in order to create a list of names and numbers, etc., but we think that it must have a role. Registration of workers is connected with registration of trade unions, and that in turn is connected with recognition of trade unions, and from recognition of trade unions into collective bargaining processes. So these set of issues must be seen together and examined with a greater meticulous process. So registration of trade unions, I won't get into because all of us are too familiar with that. The Trade Union Act or the Industrial Relations Code lays down procedure for registration of trade unions. We follow that, no doubt. But when it comes to registration, there's one aspect that we are all familiar with. It has manifested in different ways in different parts of India. There are occasions on which members of the workforce are denied registration invoking again definitional clauses pertaining to workers, etc. I am happy to point out that the Industrial Relations Code has overcome this limitation. And for that, we must all kindly look at section 2M of the Unorganized Workers Social Security Code of 2008. That section is invoked by the Industrial Relations Code in order to say that for the purposes of the trade union registration and membership, this 2M will apply. I think that's a welcome provision, and we must use it as you can now build trade unions of anybody who's in the workforce. So that is indeed a great advantage that we have just now. So from that registration process, we'll also have to remember that when a trade union is registered, there's a classical method where the trade union gets together in a general body meeting and elects its office bearers. Fortunately, from 1926 onwards, these processes carry tremendous democratic potential. There are a few cases in which that potential may have been eroded, but there are many innumerable healthy trade unions that conduct democratic elections and elect their office bearers. And, when it comes to recognition, there is still a debate whether it should be secret ballot or some other method. But when it comes to the election of office bearers of a trade union, it has, I think, more than 90% of the cases been through the use of secret ballot. So we must build on that tradition. And therefore, the returning officer of an election in a trade union must coordinate with the registrar of trade unions and with the registration authority, the district level registry, in order to match the list between those who are registered as workers, as mentioned earlier, and those who are members of a trade union. This is necessary in order to prevent the kind of experiences that Subhash Bhatnagar has been warning us about. And so I think we use this method to tremendous advantage, and that we need to examine deeper and deeper and understand how best we can carry it forward. That brings us to the question of recognition of trade unions. Now, as you know, in India, there has been no central legislation in order to recognize trade unions. It is interesting for us to note that Jagjeevan Ram, when he was the first Labour Minister of India, he moved an amendment to the Trade Union Act to introduce recognition of trade unions. That's 1947. But that was not allowed. And therefore, there has been a historical opposition, largely from the INTUC, for reasons I think which all of us know, as a result of which recognition of trade union was never provided in the Trade Union Act of 1926. Now the Industrial Relations Code is talking about recognition of trade unions. And I think we must draw on some of those principles. Though broadly speaking, I want to mention that under the IR code, you have a single negotiating union formula as well as a negotiating council formula. That idea was created long back. And I think for the informal workers, the negotiating council idea must be further developed. And that is what we have done in the manner in which we have developed our draft. So what does this mean? There must be a bargaining council created. The bargaining council may consist of all the office bearers who are elected by the trade unions of a particular sector. I must emphasize that we are talking of collective bargaining at a sectoral level. And so there must be a sectoral bargaining council which brings together all office bearers. And there must be sufficient democratic space created for everybody to work together, cutting across affiliations and political thinking, etc. Now, from that may be a very big body. From that body, we need to create a negotiating team which will be in charge of collective bargaining. To create that negotiating team, suggestion is we must follow the principle of proportionate representation. Let me try and illustrate that with an example. Supposing we want a negotiating team of 10 people, then we should give representation to different unions on the basis of the votes that have been polled at the time of election of their office bearers. It's the total votes polled that will be taken as the indicator. So supposing a union has 20% of the total votes polled in that particular sector, then they will have 2 representatives in a negotiating team of 10. If the union has 40% of the votes, then they will get 4 representatives. So in this manner, we create 10 representatives. And therefore, we are not looking for a negotiating union model. Instead, we want a negotiating council model. And that is based on strong feedback we got from especially informal sector trade unions. So that way, we feel that there will be more scope for bringing in new elements from either to marginalized trade union leadership and the sectors concerned, etc. So that's a major chunk of what we have proposed through this legislation. And there can also be a higher level body, an interstate body, intrastate only, but at a state level, which again the bargaining council can create in order to ask them to perform certain wider type of activities for the informal workers. With that, we move on to the question of wages. I think here again, all of us are familiar. I'm happy to mention that, there is in the discourse that is going on the question of wages, thanks to so many years of struggle, there is a consensus at the conceptual level that has not translated into the practical level. But at the conceptual level, there is a consensus that you have to follow the 15th Indian Labour Conference norms. And so that, as we all know, is a very, very valuable set of norms. Sometimes genuine friends and scholars are tempted to revise these parameters. But I think we must caution against revising those parameters. because these parameters have been held up by the Supreme Court. And when we say held up by the Supreme Court, while we use reptacos for the purpose of getting 25% more of the wages, we must remember that Unnichoi versus State of Kerala was the more important judgment on minimum wages. That was a constitution bench decision on minimum wage. And that too when Gajendra Gatkar was the Chief Justice. So that's the only constitution bench judgment on minimum wage. And we must, take full stock of it and hold that in our strong grip. So on that, using that method, it's possible now to calculate minimum wages. And then, I think experience has shown us that the proper minimum wage according to these norms will be nothing less than double the notified minimum wage in different states of India. So we go by that, and the important thing that we must notice in relation to the wage question is, one is that the rules framed by the wage code, central government rules, they bring in an alien element into the 15th Indian Labour Conference. That alien element is that they want to fix a 10% cap on house rent, 10% of food and clothing. Completely unrelated variables are invoked in order to push the ceiling. I think that is based upon probably a relevant consideration so far as 7th Pay Commission is concerned, because class 4 employees in the 7th Pay Commission will be entitled to their own house rent allowance. That is not the case with us, with our informal workers, and therefore there is no place for it. It will have to be house rent calculated according to the market. After all, you guys believe so much in the market process. Please go to the market and find out what is the house rent. In Bangalore, it will be nothing less than 5,000 rupees. The Karnataka High Court has upheld the fixation of approximately that amount of money, more than 4,000, by the state government in one of its minimum wage notifications. When the former Chief Justice of Karnataka looked at this matter, he has given a decision that yes, workers are entitled to house rent based upon a different yardstick than what has been prescribed by the rules. And so that we must take note of. The other thing is rate of neutralization. I think it is different in different states. The method by which neutralization rates are calculated is unscientific. And therefore, we must demand that there should be 100% neutralization for price rise. And that should be calculated on the basis of the consumer price index numbers that are produced by the Simla Bureau. And that's another important ingredient. Otherwise, there is reason to believe that very often there is erosion of real wage in the minimum wage category. That is such a contradictory thing to happen, but that also we must take note of. And the last thing in this regard is people fix a minimum wage and then make people work for 12 hours. Minimum wage is generally meant for 8 hours of work plus 1 hour for lunch break, etc. So minimum wage should be for 9 hours at maximum. And for the remaining time, if there is more labor extracted, then overtime wages will have to be paid along with the minimum wage rates. And in addition, if there is failure to pay the wage, then there is good solution provided in the old Minimum Wages Act, reproduced in the new wage code. And according to that, you can recover 10% as fine for the gap in relation to actual wages paid compared to minimum wages notified. That must be invoked strongly. You don't need any amendment. You only need to invoke it strongly. We know that collective applications can be made for this purpose. And if it becomes necessary, recovery can also be done according to arrears that are due for as land revenue. So that's a very comfortable package, conceptually speaking. And then, of course, To achieve that, you need a trade union. The extent of implementation of labor laws in India is directly proportional to the extent of unionization. And hence, we begin our narrative with the registration and recognition of trade unions. Then we move on to social security. Social security, there has been so much of discussion going on. And I'm happy to mention this All India campaign on the ESI that has been carried forward by the National Movement, Working People's Coalition. The other day, I'd come to Mumbai to participate in their meeting. They have taken up only ESI, but that's a very important contribution. We feel that we must take up both ESI and EPF and demand that it should be made applicable to all informal workers also, which means the threshold level that is now prescribed must be removed. It should be applicable at least for those establishments which employ 5 workers also, ESI as well as EPF, because as you know, ILO Convention 102 and what they have prescribed is covered adequately if you look at ESI and EPF together. Then comes, the bulk of the workforce, unfortunately, will be those who are working in own account processes. Sometimes it is one Malik and one Karmika. And so what do we do with that category? That is where we'll have to think of pension. That's the view that my colleague who works on this issue has been suggesting and working out, Mr. Mohan Mani. And so that requires further examination. And that is pension as well as minimum health facilities, picking up the basic elements available with the ESI, combining it with the infrastructure of the state government, and making it clear that resources for that will have to be raised through the state process by shifting to progressive taxation and giving up regressive taxation methods. So that is the other aspect insofar as the social security part is concerned. Then the aspect which Gayatri mentioned about, security of tenure. More and more people are of the view that this must be tackled. The whole question of contract labor or different forms of labor, hire and fire practice. So that also needs to be handled. And one kind of thinking that is emerging is you may change your contractor, the management may change their contractor, but why the hell do you want to change the contract laborers? So the type of job they do, whether it is cleaning or maintenance or gardening or security, those are all permanent jobs in a particular establishment. And therefore, they shall not be terminated. If at all they are to be terminated, then it should be for reasons that are to be shown. Show cause notices and natural justice will have to be followed. Otherwise, such termination should be considered as illegal, and there should be reinstatement on the well-known principles of labor jurisprudence that we are all familiar. Reinstatement with full back wages and consequential benefits should be the rule in this regard, and we must fight hard for that also. Working hours, I've already mentioned it in relation to minimum wages, so I'm not going to repeat that. But there is heavy pressure from multinational corporations to keep on extending the working hours. The IT sector gives so many new reasons for it and pressurizes the state governments in this direction. So there also we need to articulate our position more clearly. And then I think what remains is, the occupational health and safety questions. And there, the law so far has been rather ineffective. And therefore, we need to enhance the role of professionals, of doctors who know about occupational health and safety, and convert them into an expert committee that can play a role in relation to this. We must particularly take note of those occupations where everybody knows that it results in fatalities. Very often workers in such occupations die early, even before they have crossed the age of 40, they die. So such occupations must receive special prohibitive attention. They must be closed till they comply with basic minimum requirements. And that is also to be taken as part of the occupational standards. Of course, new standards have to be evolved in consultation with the experts and notified, and the state level body, which we have proposed earlier, should be able to conduct annual surveys and make recommendations in order to make this part of the law function better. So I conclude there. Thank you for your patient listening. And I repeat once more, this is only a draft. We welcome your inputs, and let's take those inputs and try to improve upon this draft and take it forward and make all the informal workers aware of it so that the ownership of it becomes wider. We know that this kind of law will never come into force unless there is massive mobilization and public opinion in support of it. Thank you, Gayatri and friends.
So just before we open it up for discussion, I'd just like to add 2-3 points. I think one point which was not covered after, I've read the draft, was the issue of same work, same pay for same work or similar work. So that is an important part, because in the new codes, that entire act, the Equal Remuneration Act, has been removed. And that protection which was there, which was not being implemented, but it was there, has been done away with. So this is an important part of, and if people could also discuss that issue. The second issue that I just like to focus on is the issue which I started off by saying that the employment relationship itself, we need to have some clarity on what would constitute an employment relationship. And if we have that clarity, then of course all these issues about workers being left out of the laws would become a little bit clearer. And so we have many examples. We have self-employed workers, vendors, and we have an act, the Street Vendors Act, but it is not being implemented. So there have been various suggestions on how we could collect cess for those workers from the local authorities and maybe implement the benefits relating to ESI and PF. Similarly, on sex workers, the sex workers are not considered as workers. And so how do we ensure that they also get the benefits and could be included in the definition of workers? Then we have app-based workers, which is important because you see this whole concept of factory and establishment, that everything happens within the four corners of the factory. Now that entire concept has been done away with. So you don't have a factory. You cannot identify your employer because he does not exist or he is not visible. And therefore, as far as app-based workers are concerned, it is the algorithm that controls their entire work. So basically, here you have an employer which is different in nature, and how do you deal with it? So you have concepts of misclassification. You call workers not workers, but you call them partners or agents. Similarly, for ASHA workers and Anganwadi workers, you call them volunteers. So even though they are workers working in the government, in the state government and central government departments, yet they are considered as volunteers and they're paid an honorarium, which is not considered a wage. Then you have forest workers, and of course, workers which are covered in the bill are the workers who are like the fish workers. So basically, workers in the commons who take the benefit of the natural resources. So you have forest workers, you have fish workers. The fish workers, who is the employer, cannot be identified. But he or she is utilizing the benefits of the common resources, and yet that is also being deprived because they are not entitled to any benefits. Even if they are removed or are displaced, they are not entitled to any compensation, etc., etc. So we have different categories of workers, and I think the basic concept of employment relationship is that it is disguised in a relationship, and the basic concepts would be that their work is controlled and supervised by someone else. Two, that they depend, they actually perform the work for someone else and not for themselves. So they're actually living off the wages which is given to them, and it is for their livelihood. It is not to make profit. And the third criteria would be that they are integrated within the establishment. So they become part of that establishment. They cannot function independent of it. They're not outside that establishment. So they're integrated within it. And then you would have cases where you call it remuneration, or you call it by some other name, but actually they're being paid for some work which they do for others. So these are the basic, and there could be many others. These could be the basic criteria based on which we define who a worker is, whether it's self-employed or whether it is wage workers. And finally, I'll just add that I think the bill also says that wherever boards are existing, those boards will not be interfered with, and this would be over and above the existing boards that already exist. So I think that we can open it up for discussion, and I think someone is just reading the chat boxes, and Purbayan, will you do it, or Katyayani?
Bhargav is doing it.
Okay.
Yeah, we can open up the webinar for the question and answer session. I just want to add here that I have put up the draft legislation in the chat box. So whoever is interested in reading the bill, they can check out the chat box. We will also be sharing the draft legislation on the email IDs and WhatsApp numbers that you guys have provided in the chat box. So yeah, I think we can begin with the question and answer session. Do we want to take up questions from the audience first, or should we take up the questions from the chat box? I think in the chat box we don't have many questions except one or two, and we can start with that actually. Veena Shatrugna is asking, how long will informal workers live on minimum wages? Is there a hope for moving up to wages above the minimum? Uh, so if Babu sir can please answer this question. I think there was recently an ILO article which was suggesting that India will move on to living wages post 2025, but there is not much clarity on this particular aspect. So please, if you can throw some light on this.
Yeah, surely other friends also can come into this discussion. I want to begin by saying that, there is talk in India to go in the reverse direction. And the reverse direction is what is referred to as the floor wage. But there are people in authority who sometimes call it the national minimum wage. And that is a very mischievous formulation. Unfortunately, the Congress manifesto has fallen into that trap. And having fallen into that trap, they are asking for 400 rupees as the national minimum wage. So that is because they have not examined even the wage codes seriously. So our view is that if you use the 15th ILC without a cap for house rent, and if you use a balanced diet, which it is Veena Shatrugna who has helped us to understand what is a balanced diet in Bangalore, in Delhi, and that's one reason why Delhi has the highest minimum wage in India. So yes, if you do that properly, then, Bangalore friends have calculated the need-based minimum wage to be about 30,000. I was reading the CPM's manifesto. They have quantified it as 26,000. So that's a factor we must keep in mind. But along with that, we must also realize that in India, there is fairly comprehensive wage determination jurisprudence. And so then above the minimum wage is the fair wage. There was a fair wage bill introduced, immediately at the time of the Constituent Assembly itself in Central Parliament, but that was abandoned. And so fair wage is something we can revisit. It should be something which is not a substitute for need-based minimum wage, but a level over and above the need-based minimum wage. And what criterion should be used in order to make that statutorily binding is worth visiting. And still above is the living wage. And so this talk about equating the minimum wage with the living wage is, I think, mischievous. So you'll talk of living wage in a manner in which you're pulling down the parameters that have been accepted through various wage fixing bodies, etc. So I am somebody who subscribes to need-based minimum wage, fair wage, and living wage. And there is still a long way to go for us to even achieve need-based minimum wage. And so I think that is worth continuing with. I'll stop there for the time being.
Bhargav, may I just say something?
Yeah,
So-
sure, please.
So continuing with where Professor Mathew left, I mean, in Minimum Wages Act, under Section 5, you have two methods of fixation of minimum wage. One is committee method and one is notification method. So in committee method, you have representatives from all, I mean, employers, employee, and then the government representatives. And then there's a negotiation that takes place, collective bargaining that takes place, and through that, they come to a consensus. And perhaps because of that, this need-based assessment of minimum wage is not happening. And it's very rare when this need-based assessment happens from the government side and government notifies minimum wage. So my question to Professor Mathew is, do you think, I mean, at policy level, should we campaign for getting rid of this particular like I said, so there are two alternatives, like, the notification method and committee method. So should we just get rid of committee method and have only notification method, where there will be a need-based assessment in terms of 15th ILC and RIPTA costs, and only through that this minimum wage will be notified?
Yeah, it is. I think what has been mentioned now is very correct. It's been an uphill task everywhere to break through these tripartite bodies. Even where you make a breakthrough, it's finally the political leadership which becomes even more regressive than the representatives of the employers. So that is a reality. But it is possible. We must note that when we talk of 15th ILC and repticos, etc., that's not part of the statute. Recently, an attempt is made to bring it in as rules. We should make it a part of the statute. If we make it a part of the statute, then it does not depend upon either the notification method or the committee method. It will become a minimum statutory requirement, and there is scope to do that within the statute.
Thanks, Professor Babu. Purba, should I move on to other questions?
Yes, Bhargav, please.
Yeah. So there is a question from Kabita. She is asking, if I understood correctly, Professor Babu Mathew mentioned that one important form of organizing for informal sector workers is the council model and not just a union model. Are there some examples of this in India that you could kindly point to, as well as how it's been more helpful, as well as what the distinction would be?
Yeah, whenever there has been an attempt to reform the process of recognition of trade unions, two methods are suggested. One is if a particular trade union gets 51% of the votes in that particular establishment, they become the sole negotiating unit. But supposing that is not there, nobody gets even 50%. Then other unions put together, they will form a bargaining council with proportionate representation. In Bangalore, all the public sector undertakings have bargaining councils which are elected through secret ballot. And so both these are available. I am trying to suggest that for informal workers, let us not even think of sole negotiating unit. Let's ignore that and prefer the bargaining council so that different shades of opinion from among informal workers through their trade unions can come and they will get proportionate representation. You may like to prescribe that only those who get about 10% of the votes or 20% of the votes or whatever will be counted for determining proportionate representation. That will, I think, widen democratic functioning of informal worker trade unions.
Okay. There is also a follow-up question with regards to the minimum wage question, and Akanksha is asking if you could talk about the legality of interim increases in minimum wages usually used by states as a way to circumvent the procedure laid out in the legislature.
Well, the reality is that committee method or notification method can be used. And generally, trade unions have tried not to reach a breaking point. They somehow try to push for a consensus. And even though the criteria for need-based minimum wage is really the need, yet, there is some subconscious weightage given to paying capacity. Paying capacity, according to the Supreme Court, is irrelevant when it comes to the fixation of minimum wage. Yet you find in Karnataka, we have 81 minimum wage notifications. And not all of them are the same level. The garment workers are the ones who get the lowest minimum wage. So that is based on some subconscious way of taking into consideration the economics of the industry. This is not what the court has laid down. So there is that gap between jurisprudence and practice. And nowadays, if there's a minimum wage notification, at least in Karnataka, I can tell you, 400 petitioners come together to challenge a minimum wage notification in the High Court. It's become a very big tamasha where they mobilize tons of money for themselves. And then it depends all on the judges. So we know it is very rare now to come across a judge who cares to understand labor jurisprudence. And as a result, that's the reality. Hence, I think the only way forward is through this kind of legislation to lay down the basic principles in a statutory form. So that is not open for negotiation.
I think Professor Babu, Medha Patkar from NAPM has also joined us, and she has written on the chat box that she has a few questions. If she wants to ask these questions, Medha Tai, are you there?
Yeah, thank you. Hats off to Babu and Kavitri. They both, I could not listen to every single word, but I could guess a lot of points were covered. If I'm raising any point which is already covered, you just tell me. One thing that comes to my mind is that now the industries are mostly shifting over to contract labor to the maximum extent possible. While the Contract Labor Act, it's not just the equal work and equal pay, which is also always violated, but it clearly says that the work which is not seasonal and which is continuous, there they cannot employ contract labor. Now, shouldn't we take this position? That is very, very essential. Otherwise, all the industries being run on the contract labor, for which they are retrenching, they are closing down and then selling and transferring the businesses, etc., to shift to contract labor so that they will earn maximum profit. So that is one thing. The another thing is that I think as far as the Safai Kamgar they are concerned, it is very, very this thing. Okay. It is very, very important that there should be compulsory application of the equipments which will not allow or require any manual laborer to get into the sewage tanks. We just had 3 deaths from one single family in one of our communities in Mumbai. Although they were not employed, but they on their own were compelled to get into the water tank where the sewage entered into that tank because those 2 tanks were close by and not properly built. So this kinds of such a inhuman kind of experiences is something that is should be considered while tackling this. Although 30 lakh rupees compensation is given and Gayatri ji is fighting the battles related to this issue also, but that is one thing. The third thing I wanted to, whether it was raised by Babu Bhai, then no issue, that the non-workers to be taken on as the office bearers in a trade union. They have put strong restriction on that. And that is because they don't want the workers to be properly represented by the union. That is something that we should really strongly oppose, because we know that the lawyers for taking up legal action and other kinds of secretaries and general secretaries are required by the workers who cannot afford to take up all the kinds of tasks and processes. And the last thing I want to mention is the whole process of conciliation and reference to tribunal. They seem to have weakened up. So from 1947, when probably Dr. Babasaheb Ambedkar was the law minister, that the whole process under the Industrial Dispute Act, and in Madhya Pradesh kind of state, there is Industrial Relations Act, which has little different process, but still that process they want to really dilute. And that is also we must really question and not allow. And the welfare boards you must have talked about, Babu Bhai. So I don't have to mention that. But my question was that even if these are the national legislations, there are certain state legislations which are linked with these legislations. So what is the role of the state assembly in getting these amendments or total repeal and changes into the dilute laws to be given consent? So that is what my question.
Thank you, Medhaji, for joining this discussion despite your heavy schedule. And thank you for the questions, that all of them are extremely important. I think the first question on contract labor, that is something which is used continuously to break the backbone of trade unions. And there is no dilution of going ahead with contract labor. Sadly, the first assault on the contract labor abolition and regulation law came from the Supreme Court. One decision of the Supreme Court was favorable to us, but that was overruled, and they went to the extent of saying that if contract labor is abolished, then they need not be absorbed. Who will ask for abolition if it means that all of them have to go home? So that's an absurd judgment of the Supreme Court. And if this is not enough, now the new law has repealed the old contract labor abolition. And the one that they bring in its place is a sad apology. And so What I did not mention earlier, but I used this opportunity which Medha has given to mention that there are a number of laws which have been repealed by these 4 codes, especially by the OSH codes, etc. This is combines both general law as well as sectoral laws. For example, BD workers. BD workers through their struggles have achieved so much. Even that law is repealed, their cess is repealed. So we have to pick up each sectoral legislation and improve upon what it was and completely oppose the modifications that they have now suggested. All modifications are a further dilution of standards. Some of them are absurdly incoherent. And so even contract labor would come into that category. We'll have to attack both the Supreme Court's judgment as well as the repealed and reenacted law and ask for a separate legislation itself in that regard. And I agree about manual scavenging. I'm happy to say that in Karnataka, we have a strong trade union of manual scavenging workers, and they have been able to get small concessions from the state government from time to time, especially in respect of the amount of compensation to be paid, etc. A few friends are now conducting a survey in order to make a list of all manual scavengers who are in employment. The government has recognized about 50,000. That is not the full number, but even that process is going on, and that's because of the strength of the trade union movement in this regard. They have leaders whom they have produced who can stand on their own. And of course, technology and the use of technology, on the one hand, yes, in order to prevent workers from getting into the manholes and getting suffocated to death, technology is required. But when technology is used, the moment technology workers are required, then they dispense with the Dalit workers. And they begin recruitment of other kinds of workers in order to fill up the new kinds of vacancies. So that's another tragic dimension which I think we must take note of. About what you mentioned as non-workers, that's an old attempt to destroy the trade union. I remember before the first National Commission on Labor, which was presided over by Gajendra Gadkar, this issue was raised. And Gajendra Gadkar's reply, that is 1969, was, why do you interfere? You leave it to the trade union. When the workers feel that they are mature enough to handle their trade union, they won't go in search of outsiders. But so long as workers want outsiders, that is a matter of their internal democracy. Our Trade Union Act has always provided for it. And so, yes, these attempts in order to dilute that. On the one hand, on the negotiating table, you find professional managers who have master's degree in so many subjects. They sit at the other end of the negotiating table, and then they want only uneducated workers to be on this side of the negotiating table. So it's not a level playing field. And in that sense, I don't think conceptually they are justified in wanting to do away with what is known as outsiders. But you have used a more dignified expression of non-workers. And yes, I think they have a legitimate role. The other ones who have contributed in a big way to the evolution of our trade union. And the last thing I think which you mentioned about conciliation and adjudication, Mehtaji, it has reached a stage where people are fed up with adjudication. And that is largely because those who are appointed as presiding officers are people who have served in the civil judiciary and the criminal judiciary. And when they are reaching the age of retirement, then they are posted into these positions. So the first 2-3 years, they're sitting and learning labor law from the lawyers. By the time they have learned labor law, they retire and the next batch comes on. So they have made a fun of this. I think it is Justice D.A. Desai, when he was chairperson of the Law Commission, he said you must have a separate cadre of presiding officers for labor adjudication. So that's the right direction to think of. In the Industrial Relations Code, they have now abolished reference. And when they abolish reference, they are saying a worker can make an application to a tribunal. I fear Gayatri must add more, of her on her own experience in this regard. When you ask workers to make an application to a tribunal, that's not how it was done until now. As you know, it is always through a reference. When you do it through an application, it becomes quite similar to what you do in a civil court. And when you go to a civil court with a plaint, then the burden of proof in respect of issues depends upon the particular way in which pleadings take place. Whereas in a reference, generally, the burden of proof is placed on the employer. The usual question, is the management justified in dismissing so and so? If not, what is the relief? What kind of relief should the worker get? Now, if you take away reference and bring in applications, you're going to contract law. And contract law is the opposite of labor law. And so this is a well-studied all-round attack against everything that we have won over several decades. And I agree with you, we need to address each of those. Thank you for raising those issues.
Professor Babu, Suhas Kolekar has his hand raised. I request Suhas Kolekar to go forward and ask the question.
Thank
Please
you very
be
much.
brief in your question because we have some other questions in the chat box.
Yeah. We all citizens have a right to life with dignity, but for the workers, the dignity is never thought of. And especially the women workers face a lot of problems. So is there any place for grievance redressal in the whole draft? That is one question. Second thing is, while calculating the minimum wage, it should be calculated on the basis of affordability of nutritious food for the entire family, not just the ration which just saves you from starvation death, and education and health rights, at least from the public sector. So these are a few of my suggestions and questions. Thank you.
Yes, I agree fully with the second question that you raised. When we talk of a 2,700 calories, we always bring into the picture Dr. Aykroyd, who was a nutrition expert. And so he had suggested a diet chart. And that diet chart has all the ingredients of a balanced diet. But I saw that Veena Shatrughna was also there in the audience. She is the one who has worked it out concretely in India. And wherever people have heard her, that has contributed to the calculation of the need-based minimum wage. We need to do that systematically. The information for that is available. And we also know the kind of games that are played. If you want to see how crudely the games are played, so look at the Second Pay Commission. What they do is, from the diet chart, they remove fish, they remove meat, they remove eggs, they remove fruits, and then construct 2,700 calories. So these are situations where the final amount to be reached is determined, a priori, and then you work it out backwards in order to find a diet chart which will produce that necessary result. So we certainly reject that, and I agree we must ask for a proper balanced diet. And about the question of dignity, yes, workers are also citizens. And in any case, by virtue of being a worker also, our constitution guarantees dignity for us. And of course, these are periods during which everybody's dignity is violated left, right, and center. And I think the example which Medhaji pointed out about manual scavengers is the leading example where dignity has been denied for so many years, even after statutory provisions guarantee dignity. So that is part of the basic struggle which workers have to take up. Unfortunately, it will have to be led by the informal workers. The formal workers in India have become the equivalent of labor aristocracy. And that is a sad development. But without shedding tears on only that, we have to organize the informal workers. There is no other way forward.
Thank you, sir, for those answers. Aju John has a question, and he writes, if the enforcement of wage standards and occupational safety and health standards still relies on a functional labor inspectorate, does this leave the law open to sabotage through budget cuts? And there is a follow-up question. There is a research from Kerala showing how welfare board administration has been used by political parties to extend patronage. Same research also shows how the administration budgets have even dwarfed the social security funds distributed. Any steps taken in the draft bill to counter this? Uh, and further, Shiraz also adds to this question, the boards exclude genuine workers while bogus workers are easily included. So
Yeah.
if you can please reflect on
Yes,
these.
I begin with the last observation of Shiraz. I agree fully with her. I think this representation of workers on boards is a big sham. It is a form of patronage that the ruling party in a particular state extends. And generally, as a result of it, you have the most undeserving persons occupying positions in the name of workers on such boards. So this process that we have suggested of registration, recognition, collective bargaining, creating of a bargaining council, these are methods in which workers themselves decide who their representatives should be. And through that process, all these levels of representation should be fulfilled. But that is easily said and done. I must mention that, for example, in the banking sector, there is worker representation at the board level, but I don't think they have lived up to the type of tasks that they ought to be doing there. Of course, AIBA has played as a trade union a marvelous role, but getting workers to play a democratic role is an uphill task. And the first step in that is it should not be filled up through political patronage. It should be through a democratic process. And that I fully endorse and agree with. Sorry, I forgot what were the earlier questions.
Labor Inspectorate.
Aju John was asking.
Yeah, can I just go? Can I speak the question now?
Yes, please go ahead.
Yeah, my question was, if you're relying on a fully functional labor inspectorate for the enforcement of wage and occupational health and safety standards, then does that not open up the draft bill to sabotage through budget cuts of labor inspectorates?
Yeah, I don't think any of us believe that implementation of labor law can depend upon the inspectorate Raj. And that criticism has been so forceful that the 4 new labor codes misuse that criticism in order to say that now labor inspectors will also become enablers, I suppose, for the management. So they have, in addition to that, said that all prosecution will be subject to compounding of offenses, and there will be fines recovered which will be put into some welfare fund. So the whole concept of creating implementation through inspectors, I think, is a lost cause. Therefore, our emphasis on collective bargaining. And it is through unionization that implementation. I think it's worth noting that where there is a strong trade union, not only is labor law implemented 100%, sometimes it crosses under 100%. For example, payment of bonus, the maximum is 20%. There are factories in which 40 and 60% bonus has been extracted. That I'm not recommending that model, but it's an indication that strong trade unionism is the best way to expect higher implementation. But I think I saw Rakshita's name on the screen. She is one who has been talking about other methods of achieving transparency, accountability, and social audit. And I think we should move on to that, which has been tried out to some extent in NREGA and situations like that. So there's a wealth of information there, and I think we should bring that on board in order to try it out in the labor field. That is in the spirit of RTI and follow-up actions which have been suggested. So I don't place much faith on the labor inspectorate.
Thank you.
There was a question from Jayashree, who is a Supreme Court lawyer. Is Jayashree present? Can you go
Hello,
forward and ask your question, please?
hello, Babu, Mathew, and hello, Gayatri. It is really nice to hear both of you. It is rather a comment in the context of Tamil Nadu. Tamil Nadu, we have seen the similar trajectory where as soon as a notification is issued to revise the minimum wage, number of industries, like tens and hundreds of them, just flog the High Court just to get a stay order and stall the revision. In last 6 months, what had happened is that the matter had come before the Supreme Court, before Justice Geeta Mittal, and she had issued a very stern order directing the government to revise the minimum wage. But in spite of these very strong orders and literally kind of shouting at the lawyers of the respondents in the court and asking them not only to issue one notification but to count for the last 10 years and issue the notification. The industry has very categorically stalled such revision and had multiple meetings and have opposed revision, and have also the state government had issued the draft notification and they want to dilute it further. The matter is listed again on the 23rd of May, 23rd of April, and we have to see what would happen. And if we manage to get this notification and revised minimum wage, I think that will be a massive victory. Similarly, in Assam, for the last 10 years, the minimum wage has not been revised. As in when the elections are ahead, the government raises about 30 to 40 rupees of interim wages, and the chief minister has categorically said to the groups advocating for increase in wage that इससे आगे कुछ नहीं हो पाएगा. Like, don't even dream of any increase. We have also seen problems in unionization on ground. The unions which were in Assam, there was a ACMS, which was Congress affiliated union, and while it was not a true representative of workers, in last 10 years with the BJP coming in power, that union has become toothless and there is no union which would represent the workers. In Tamil Nadu, again, because the migrant population, large migrant population, and the local workers are not unionized. So we are we are trying to get into unionization, but it has been a massive struggle. Also because the workers in Tamil Nadu are migrant workers, and in Assam it is the options are very limited. There's a BJP affiliated union and there's a Congress affiliated union, and neither of them are representative of workers. And if at all this new codes gets through, then we think that this negotiating union provision will really become a big hurdle in realizing workers' rights. Thank you.
Yeah, I'm in agreement with what lies behind each of those comments. So nothing to add from my side.
Okay, I think we have 3 or 4 more questions. Shiraz, your hand is raised. Do you want to go forward and ask your question?
Yes, I have raised the issue in the chat box also, that we are not addressing the issue of non-payment of earned wages, and this is affecting the most vulnerable section of the working class, which is the seasonal migrant workers. And I think it is quite a widespread phenomenon if you're working amongst these workers. So this is something I thought wanted to flag. The other thing I wanted to flag was that now with all these changes, whenever one goes, files complaints with the labor officers, uh, you are forced to start negotiating with the subcontractors or the subcontractors. And the whole idea of the principal employer being liable has somewhere or the other faded away. And I think we need to bring that very strongly into our discourse. Because unless the principal employer is made liable, recovery is going to be near impossible. So these were two issues I wanted to flag.
Yeah, I think both are extremely important issues. I was mentioning that if the non-payment is in relation to minimum wage, then the good old Minimum Wage Act of 1948 has a very effective remedy, provided you have a well-informed trade union which can raise that remedy, meaning you can make a collective application and also demand fine for the gap insofar as the wage differential is concerned between the actual and the notified. But if it is not a minimum wage category, then you may have to fall back on the Payment of Wages Act, which also again is a quasi-judicial proceeding, and that can also be helpful. But finally, it is the strength of the workers and their organization. So there are these half a dozen, it's about half a dozen issues which are critically important. And on that, we have to learn new forms of campaign so that the workers' voices, come out into the open. And I think otherwise you are right. That's the same story with reference to the use of contract labor and employers hiding away behind it. There is good old labor jurisprudence in order to tackle this. Long ago in the BD industry, Justice Krishnaiyer has laid down what should be the yardstick to find out who is the principal employer. Those are still valid. But I think one part of our effort, it will have to be multi-pronged. One part of our effort will have to be to make some of these standards, a floor level of standards as part of a statutory framework. But statutory framework, as somebody was asking, we should not depend only on central legislation. Nothing prevents a state government from enacting a statute. The constitutional framework allows labor as part of the concurrent list, and therefore it can be taken up even in that regard. And there is creative potential to use constitutional law interpretation pertaining to what is repugnant and what is not repugnant in order to encourage state level labor legislation. So in the coming period, depending upon what kind of a political scenario we are going to see, these multiple efforts will also have to be made.
Sure. I just wanted to share one more thing, one more experience actually, which kind of shows the way forward. Once there were these tribal workers who were not paid wages for having worked in the Bombay Port Trust lands, gardens, and things like that. And when we took the matter to the labor office, they insisted that we negotiate with the contractor, which was becoming impossible. Then finally, one day I just walked into the Bombay Port Trust union office, Transport and Dock Workers Union office, and the general secretary took it up and the wages were paid. But the labor office refused to recognize the Port Trust as the principal employer and refused to issue any notice to the Port Trust.
Yeah. I think we are lucky that you have a sensitive, organized trade union.
Exactly. And this is something that we have to really work towards, that you have the more organized trade unions really helping out some of these sections of workers.
Yeah.
And that kind of sensitivity has to be developed in some kind of organized way of working.
Yeah.
Professor Mathew, we have two related questions on the migrant workers particularly. Preeti, who is a co-founder of Center for Labor Research and Action, she writes, "It is a challenge to unionize migrant workers. Thus, there should be a strong district council. A strong district council should prevail." And Suhas has also written on similar lines. Is there any provision of grievance redressal in the draft bill? Migrant Adivasi women are very brutally exploited. We need something like a board for grievance redressal. If I am missing something in these questions, Preeti, please feel free to add. Uh,
Yeah, thank you, Bhargav, and thank you, Professor Mathew. These two issues you have flagged, those are important. But I'm sure all of us know, Bhargav, you also are working in the sector, that the seasonal migrant labor, which is a long season, this is 7 to 9 months. So it's not like even the construction workers, for example, in Gujarat, they are technically here all around, but they are still considered seasonal. In any case, there is this challenge to, of course, unionize them. So strong district councils is what I say. And this whole board business really only, it orients towards more welfareistic kind of, it's welfareistic orientation. So, and of course, the budgets, then they get involved. And so I think we need to bring more and bring the whole gamut of informal workers' issues, their exploitation, their rights, everything related to them that has been discussed, more into the legal rights statutory framework, rather than leaving it to boards, because the board changes its schemes suddenly, it changes its budgets. So that is something that is extremely it is very indefinite, it is very unstable, and they don't get addressed. And there is a tendency for now local labor being displaced more and more by migrant laborers who work long hours, who can be controlled, and who can be exploited in many more ways than, say, local workers. We found that the organized unions are generally, at least in Gujarat, not very amenable to taking up these issues for the unorganized sector labor. So it is important that the district council actually become, or the labor courts, for example, which are very, which can be very effective if they are strengthened, and if their structure is changed to make them address the issues of the unorganized sector labor. They can be more and more mobile courts. They can be more. They can include more sectoral issues, etc. So that is my proposition from my experience with the unorganized sector labor in Gujarat. Thank you for allowing me to speak.
Thank you, Preeti. Yeah, I think, the Interstate Migrant Workers Act of 1979 has a good framework, but not much was achieved in its implementation, especially because of the need to coordinate between states. But sadly, even that good law is repealed and is replaced by a hugely truncated legislation. And what we must note is that in the old good law, even that one neglected migration within the state, intrastate migration. That framework is good, and I think we must go back to club it along with the various suggestions that you have given in order to reapproach that question. I'm glad that organizations like Ajivika have been working night and day to address these issues. And I think that universe must be expanded.
Yeah, and there's just one more point where it has to be now very well understood. Bhargav understands it also very well, that the level and degree of exploitation of migrant unorganized sector labor is extremely intense. And so to address them, for example, we've had to use more and more, not the labor not the labor governance structure, rather the police most of the time. You see, they are so severe, some of the exploitation methods. So it this particular class of laborers just need to be addressed in a very special way, and every district must take into account all the migrant labor that is coming in and register and list those two. And of course, interstate coordination will have to be, I think, put into this codes also. It has to also become statutory. Yeah, thanks.
Okay, thanks, Preeti. Babu sir, do you want to add anything to our observations or?
No, I'm in agreement with what she is saying. I only want to mention that this code is not the only framework that we are thinking of. We are wanting to revisit all the sectoral legislation. So migrant workers has a special legislation that needs to be re-looked at. And in that manner, many sectoral laws have to be revisited because there are sector specificities which need to be addressed along with this.
There is an observation from Raj Lakshmi Ram Prakash. She is asking, these are important discussions. Just a comment on occupational safety and health. I think this framework needs to be expanded beyond accidents to include everyday stressors, mental health issues, work itself as causing ill health. And to address this, we need socially minded health professionals, not any quote unquote doctor.
I'm fully in agreement with that. And, thanks to our friends in Chennai, there is one Dr. Manivelan who has been all his life focusing on occupational health and issues. And so there are not many of them, but the few that are there, they must be brought together. And this particular person in Chennai is very helpful to the informal workers. We've been interacting with him thanks to Geeta Ramakrishnan. So I think I agree that must be strengthened. That professional input is very important at this stage.
Indira Uninayar is asking, I represent street vendors who have had a legislation protecting them since 2014. We had pressed for a legislation. They are largely self-employed. Despite a legislation, they are often invisibilized and termed encroachers. They are denied dignity. Their wages are, their wares are thrown and destroyed. Would you term them a sector? Do you have any inputs regarding them?
Yes, I would think they are a sector, but we should not say sector and then allow the fragmentation of the informal workers to continue. How is it that you can build strong coalitions and alliances? I think from history, we know the way to achieve that is people belonging to one sector should be able to understand the problems of people working in another sector. It is only through that process that you can build that solidarity. And therefore, while the street vendors have achieved a very powerful legislation, some of the provisions in relation to democratization of street vending committees, etc., are very far reaching, not to be seen in any other law. Yet its implementation is extremely poor. So I think, we have to find methods by which different sectors can collaborate with each other. And that's otherwise the fragmentation will keep us weak. So you need a combination of sectoral approach along with solidarity between sectors.
Thank you so much, Professor Mathew. I'd just like to supplement a little. There's also a huge disincentive to implement the law because street vendors are, are forced to pay hefty bribes. So there's a very well-oiled extortion machinery that prevails across the length and breadth of the country. And therefore, there is no incentive for any body, whether it's a government body or a municipality, to this law. the rights, the duty of implementation has been given to the state governments and not the municipality. But unfortunately, the municipality are using the municipal laws to override this overriding legislation, if I may say. And unfortunately, because this extortion, it's very difficult to make headway. Markets, entire markets are being wiped out. And just like you talked about, what is it, sham bodies being set up, these committees are filled with sham people, and they're headed by the very people who are, against whom you are standing up, the district commissioner of the municipality, etc. So do you have any insights to offer? Because we're struggling, and also we're struggling with the reputation, the lack of reputation that they face, because they invisibilize and label the encroachers. And straight away, when you stand before a judge, the first thing that you face is, oh, here is an encroacher. Why are you protecting this encroacher? So, so I just thought I would share some of my woes and also ask you if there is anything that you can say.
No, I've been following this issue with a great amount of concern. And, we have to all think together to see where the breakthrough, if any, is possible. Perhaps even this Town and Country Planning Act, are there other pieces of legislation which can be invoked together and therefore bring other, constituencies into this issue? So I feel that we have to, create new clusters of sectors that face similar kind of problem. And the old adage that there is no other alternative to struggle very often comes true, and that must carry on, I suppose. It's a difficult task, and you will have to have intersectoral collaboration for solidarity.
Sure. Thank you. Thank you so much.
Professor Mathew, we have a last question from Chirayu, and then we close this discussion. Chirayu wants to ask if Professor Babu could share his views on whether the collective bargaining for informal workers should follow a different model than that for organized sector, which prefers collective at the industry level, code of discipline. If so, how could a different model be envisaged?
Collective bargaining.
Correct.
Is there something more which is to be said now?
Chirayu, are you present in the participants panel?
Hi, sir.
Hi,
Good evening.
Chirayu.
Sorry, I missed the first half an hour of your lecture, sir.
Okay.
So that was my question, sir. Like my understanding of the organized sector is that the collective is always preferred at the industry level. That the bigger the collective, the better it is for the workers. Now, my question is whether that can be, is that a suitable model for the informal workers also in the unorganized sector? What would?
Chirayu, I agree with you. I don't think we can reproduce the collective bargaining model of the organized workers. You're right. That is, with rare exceptions, it takes place at the enterprise level. For example, if you look at a banking sector or insurance sector or railway sector or airline sector, then it is not at the enterprise level, it is at the industry level. So we must learn from those experiences. That is why in the draft code that we have been circulating, we are talking of sectoral level, collective bargaining. Sectoral level will have to be at a higher level than the enterprise level. And that will depend upon the type of sector, but it will have to be certainly at a wider geography, which might even include the district level. So depending upon the type of unionization and the number of people in that sector, but it must certainly move to higher level than the enterprise level. At the enterprise level, you may pick up a few issues, like grievances, etc. But proper collective bargaining issues must move higher up the ladder. For example, if you're talking of gig and platform workers, You'll have to combine dealing with a particular type of gig and platform workers at a certain lower level, and then also take up that issue at a wider level, which may be district level, etc. See, when proposals for law reform among gig and platform workers is attempted, I have participated in 2 or 3 of them. Then the aggregators come together in order to collectively defend their own interests. So they are accustomed to working together. And so I think we have to shift the collective bargaining model in the informal sector to a different plane. The other important difference that I would, we always cherish the idea of a sole negotiating union. I think that is inappropriate for the informal workers. Very often, some of the best work that is being carried out are not necessarily the type that would qualify to be a sole negotiating union. And that is why bargaining council is a superior method. And so we propose this proportionate representation in the bargaining council. I'm afraid I dealt with some of that in the first part of my talk, and perhaps you joined in.
I was there, sir. I was there. I heard
Oh.
on the bargaining council.
Okay,
It is just on the question of whether there's a conscious thought behind this, that the collective should be at the district level, not at the enterprise level.
Yes, yes, yes. But it will depend on the type of industry. Sometimes it may be another geography at which you have to. It may be, if you're thinking of gig and platform workers, it will have to be geographical levels. So there's a lot of need for innovation and innovative practices at that level.
What I follow is that there cannot be a set formula for all the informal sectors.
No,
it would have to have its local variants and the variations on the sector levels also, sir.
Yes, I agree with that.
Thank you, sir.
Okay, so thanks a lot for those responses, Professor Babu. There is one last question, and I think this is like the final question. And after this, we conclude the webinar. And Armighty, am I don't know the pronunciation. Armighty,
Almighty, yeah.
Armighty.
Almighty, you can speak, yeah.
Hello, Armighty. Are you there? Can you go ahead and ask question? Hello, Armighty. Hello.
Or alternatively, you can type in the chat box if in case your mic is not working or something, and we'll read it out for you.
Okay.
No, I just got my mic unmuted. Just one or two.
Yeah.
One or two questions I wanted to put, because Safai Kamgar, the workers who work in the cooperative societies in the buildings, they are neither covered by the Domestic Workers Act Welfare Board, which is there in Maharashtra, and neither they are covered by the Industrial Disputes Act, because cooperative societies are not eligible to move the means in the court. So I just wanted to know whether there are any minimum wages for them, or under what legislation will they come, and how can they raise their demands and all, so that and get the minimum wages. So that is one thing. Secondly, the ASHA workers. Now in this informal act of the workers, the ASHA workers and all the scheme workers like Anganwadi, ASHA, midday meals, they are basically working under the schemes of the government, and which are different from the other informal sectors like construction workers, domestic workers, etc. So and they have been declared in the Supreme Court judgment, in the gratuity has been given to them by the Supreme Court, especially the Anganwadi workers. and they have been considered the hands of the government in implementing all the schemes of the government, especially giving education and nutrition to the poor. So in what way they will be covered by this act which is being drafted now, and how can their demands also of becoming permanent workers be fulfilled? Also, the Mathari boards are being weakened now, and the domestic workers board is just a welfare board, and there is no provision of proper finance by the government. If the political party is inclined to finance the board, then something comes forth. Otherwise, they are just interested in giving some sort of finance or some gift to the workers at the time of elections. So these things also, how they are going to be dealt with, and the minimum wages also that should be there for these workers. That is all.
Yeah, I think at the beginning of our discussion, Gayatri Singh had addressed some of these issues and also suggested the importance of, working on principles in order to cover all these areas more comprehensively. I think that should be one follow-up from today's discussion. And so people who have that inclination, especially those with a law and social science background, should help in articulating, the position in relation to workers, who is a worker, who is an employee, who are the employers. There is a lot of work which deserves to be given attention to. Perhaps Gayatri should come in once more in order to respond to this question also. I think minimum wages can be extended to many more sectors, and minimum wage statute itself does not come in the way. And I think so that also must be parallelly explored. But there are conceptual issues. We have tried to tackle it in our draft. As I mentioned, our approach is to move towards universal inclusion of every category of informal workers, be they wage employed, self-employed, whatever. And so that's the route in which I think we must continue to think. So there's need for, the group of people who are listening here to join hands in order to do some more research and strengthen our conceptual and legislative effort even more.
I think, thanks, Babu, Mathew, thanks a lot. You were very comprehensive, and I hope people got encouraged to participate, not just to listen, but to participate in formulating it more and understanding the concepts in the bill. In fact, it helps in raising many issues that have been raised by activists and trade unionists, but have not really been formulated in such clear terms. So I would just thank everyone and conclude this with the note that let it be an ongoing process. What has been started by Babu, Mathew, and others, let us all contribute in terms of expanding it, including other concepts, including other workers. I mean, there are so many different categories of workers. Each sector has been working separately for a long, long time. And this is one way of getting everyone together. As Babu Mathew correctly said, that we will have to break that, that sectorial approach and bring everyone together. Of course, it has its own uniqueness, its differences in terms of how we deal with it, but that's the way in which we will be able to go ahead. So considering all these differences, in fact, as Amaiti said, the Mathari board is now being dismantled. It was one of the best acts that were enacted, even though many, many years back in the 1970s, but it, with all its limitations, it was able to expand and give benefits to the workers in terms of PF, gratuity, etc. there are many pitfalls in all the boards, and I think the weaknesses in the boards, we need to deal with that and make it more positive in terms of how we can better the functioning of these boards. So I think we should learn from the experiences of everyone who's working on these issues and get everyone together. Unfortunately, in this webinar, we were not able to get people from the south, and that is Tamil Nadu and Kerala, who have really experienced the different boards that are functioning in those areas. There are some people here, but I think we need to make it more expansive. So with this, I just thank Babu, Mathew, and everyone who has participated, and let us hope that we will continue this discussion. Thank you.
Thank you from my side for this wonderful opportunity. Very educative for me. Thank you.
Thank you. Thank you.
Thank you, everyone. Thank you.
Thank you, Bhargav.
Thank you, everyone. Yeah, thanks. Thanks for staying back.
Thank you. Thank you. Thank you so
Thanks,
much.
Professor.
Thanks a
I
lot.
think Bhargav
Very
had an announcement to make. Bhargav, please go ahead before people leave.
Yeah, just for everyone who is just staying back, if you can just stay back for just 2 minutes, just wanted to talk about our platform, which is called Najar, Najar. It stands for National Alliance for Justice, Accountability, and Rights, and the present webinar is the second such webinar that we organized. Yesterday, there was Ambedkar Jayanti, and there was another webinar on the various issues and legal access that could not be accessed by marginalized sections, including Dalit minorities, SC, ST minorities, etc. So this is a second such webinar in that series, and another is basically a collective of legal professionals, which includes law students, law researchers, practicing lawyers, law faculties, and this has been supported by National Alliance for People's Movement, NAPM. So if you are interested in joining Najar, then do drop me a text. I'll put my email ID and my phone number in the chat box, or you can reach out to any of our other sathis present here. And yeah, I really want to thank Professor Babu Mathew for agreeing to give this to be part of this discussion, and very and laying out the whole process of how this legislation was conceptualized, and what are its structural provisions and everything, and Gayatri ma'am for outlining the bill and moderating the discussion. So thanks a lot to both of you, and thanks a lot to all the other sathis, Meera, Purvayan, Karina, Katyayani, all of you who played a big role in organizing this webinar. So thanks to all of you, and yeah, we can close this webinar now. Thanks.
Thank you, everyone.
Thank you.
Thank you.